May
Orders item number 1. Next.
May your lordship.
It is an urgent matter, my lordship. It is an urgent matter. It is an urgent matter, my lordship.
Next case.
After this bench. Are you from outside?
No.
You are not from Cuttack.
My lord,
Today, my landlord has filed an affidavit. Only objection to the select list is, I have received a copy. What they are saying is, clause 8.7 of the resolution says there is no provision for waiting list. That is why they are not publishing, they are not complying my lord's order. That para 6.3 of the, sorry, 6.3 of the judgment. But my response submission is 8.76 only reads about 8.7 of that resolution, 22.8.23 resolution, only says about there shall not be, after the counseling, there shall not be any waiting list. But what the honorable court has directed is not for a waiting list. What it says is, if you have the list and there are shortfall of the vacancies, you have to recast a select list, reducing the cutoff to a lower stage, so that all the posts will be filled up. There will be no dearth of teachers. That is why my lord has kindly seen my lord's judgment.
my lord, I want to mention that
The judgment was delivered in peculiar facts and circumstances.
Yes.
See, going strictly by the advertisement, what was being done was not correct, and that was rightly interfered with by the learned single judge. But noticing that the policy itself was discriminatory, that order was passed. Otherwise, they would have been accommodated somewhere. Now, if you want us to clarify and to pass an order, we'll do that.
Yes.
Otherwise, you want us to do, we'll do.
Because, Your Lordship, there is this word that there will be no waiting list. That is what is constraining the officer.
We will do.
You also look to your lordship's last 4 lines. That is the important. Last 4 lines of your lordship's judgment read appeal. State is the appellant. At their instances, it goes without saying. Let's look to that last line of your lordship, paragraph 65.
Page 65 of the I.
Order 10-12.
It goes without saying.
IN number 7968.
Just. Yes.
Para 65.
It goes
Paragraph.
65.
Yes.
In view of the admitted fact that score of the lead petitioner in the online CBT is less than the minimum marks scored by the candidates declared successful by the OSEPA, subject-wise categorized, we allow the state appellant to appoint such candidate taking into account their merit based on the score of in CBT and district preference.
Yes. It's so clear.
The last line, sir.
Last line.
It goes without saying that the cases of the lead petitioners shall be considered against the leftover vacancy in terms of the direction as above. Now about 6,500 vacancies are there.
It needs no clarification further.
Sir,
But only they are now raising
this question, sir. Question of waiting
Only
list and all this.
this much clarification will do, my lord. Kindly see, today's IA they have filed.
Your
Page
Lordship,
16.
8.7,
Yes.
that is clarified, that would help the authorities in
Page
taking further.
Yes, today's.
And so far as my case, my application is
Counseling.
concerned, my cases were disposed upon all these cases on 12th. My cases were disposed upon 12th in terms of these judgments, which was subject matter of charge. That is the last time you also I wanted to
Clause 8.7 says, my lord, shall I read, my lord? The candidates will be called for allocation of schools through counseling by respective districts. Separate notifications will be issued and displayed by respective district in their district website as well as the OSEPA website. Vacancies remain due to the unavailability of eligible candidate, rejection and non-joining will be carried forward and recruitment will be done subsequently as per requirement. There will be no waiting list. They are now only taking
these three.
this 8.7. But in view of my lord's judgment,
Very clear.
this is only that much clarification will do, my lord. 6,000 people will get them.
Candidates had, all right.
Your Lordship, there were 20,000 posts that were advertised, out of which around 2,000 SC and ST candidates posts that remained because of the non-eligibility of the candidates. They remain
So,
vacant.
all right, we are putting another question. The candidate who ought to have been recommended on the basis of your previous process of selection. So what ought to have been the cutoff? Minimum, like for any district.
That
He
you
could have
also
got a job.
clarified. You also have said cutoff back can be changed from time to time by the state.
That Chintamani Bhila has got an appointment.
And
pursuant to
8
that
points,
earlier one.
see, there is no cutoff. Cutoff is the basis of vacancy. It is-
Last candidate, whatever the mark secured, that is the cutoff.
One line that there should be no waiting list, that is what.
I also clarified that.
Please, your lordship, if I'm not quoted.
Okay.
But that is what I had a
It was-
discussion with
All
them.
right.
If that is clarified, it has.
And
Comments they
you
have.
can also look to paragraph 4 and 5 of the judgment.
16,009 candidates were placed in the merit list, out of which 13,033 have joined. And your lordship, the others are in the processing where their medical certificates and certificates have been verified. And 2,000 seats of SCS.
Rather, you should have come with an application
Yes,
that,
sir.
see,
Yes,
this is
yes.
the situation. We can appoint them, but we are not in a position to do that because of that clause. So you should have sought clarification, we could have clarified it. Instead of them coming to this.
Sir, I have a limited figure. You also look to paragraph 4 of the judgment. You also have said, notably, there are 4 written applications. Kindly come to paragraph 4.
Yes.
You also judgment, in each appeal. Notably, there are 4 petitions in WPC number 978 of 2024 and WPC number so and so. Then para 5. Thus altogether 58 petitioners. If you also look to page 154 of this case, my order was passed on 13-3. This order was passed by the single judge on 12-3. On 13-3 in terms of that 978.
No, don't worry. In fact, it is not that
That you are-
the order shall be confined to the
Okay,
petitioner.
that's
Even those
that's
who had
right.
not approached
just to remind you.
this, so madam, we'll pass order on third.
If my lord,
Lordship, in the meantime.
if my lord will clarify, I have my suggestion, my lord. Today, these boys, they may get an appointment in this year.
Chabis instead of 25 they should get.
If my lord pass today also, it's small. I don't know how much
Because Ashwini is
I
precise
will
on
take
this.
to my lord, because my lord is hard pressed. But they will get leave here. It will be happier for them.
They only want to clarify
Only
that
this
wait
much.
list cannot be here, cannot be. That is the only fee they have taken, nothing else.
Marks are there with them, man. Only they will, number of vacancies, the cutoff they will fix. That are end of the matter. Whoever is coming, he will get the appointment. That's all.
Not ticket was just ticket.
What is your number, IA number?
IA number 7964. 7964 of
My number is 8547.
that is a flag C.
Not deep.
In relation to the process of selection or appointment to the post of junior teacher bracketed schematic initiated with the issuance of an advertisement on 10/9/2023 by Odisha School Education Program Authority bracketed OSEPA we had delivered a judgment on 18/6/2024, operative portion of which reads thus. IN number so and so have been filed seeking clarification to the said order on behalf of some of the parties to the said proceedings
Yes, respond.
who have not been given appointment despite the observation made in the aforesaid in paragraph so and so of the judgment dated so and so. It appears that the cases of such candidates have not been are not being considered by the respondents on the ground that there was no provision for a waiting list in the advertisement comma as mentioned in clause 8.7 thereof.
That is not the advertising, government resolution.
Government resolution.
Government resolution.
Government resolution. Rather.
Dated 28/8/2020. 22nd.
So stop. It is not in dispute that it is an admitted position that the posts of so and so teachers, what is that teacher?
Junior.
Junior teachers.
Junior
schematic.
teachers schematic. How many posts are vacant?
More than 6,000.
6,322.
16,009 candidates were placed in the merit list and issued engagement orders out of 20,000.
Thousands of posts which were advertised against which the respondents had applied are still vacant. So stop. Neither the advertisement nor the is there any minimum marks?
No, nothing.
No, but you cannot appoint someone who has put 0.
Yes.
That is also not there.
Qualifying mark.
They have a CPT and descending order, the marks are to be treated. That is the ground.
There is no qualifying mark.
Qualifying.
In such view of the matter is that it is clarified that since the respondents are seeking selection against the posts which were advertised and against which they had applied, comma, we clarify that the said resolution in clause, said provision in clause 8.7 of the resolution shall not come in way of the appellant state of Odisha, state of Odisha, in giving appointment. Now, OSEPA will recommend, no? Of OSEPA in making recommendations and the concerned department in making appointments based on respective merits of the candidates against the post advertised. That's all.
Only one line. We are not the respondent in those appeals, but we are the petitioner in the writ application which they are not challenged. But
So therefore, we have mentioned
you also refer
respondent.
to that respondents. So only one line you have to clarify those persons, those who have also come to the court.
All
And got the order.
No, therefore we have mentioned
All
merit,
merit certificate.
merit, not no
All.
respondent. No question of respondent.
I will say it's all.
No, we further clarify that the respondent state of Odisha shall not, that the state of Odisha / OSEPA shall not, comma, for the purpose of implementation of the present order, distinguish the cases of those who had approached this court and who had not. We will see. Bit alteration.
Would like to.
Not file this affidavits, e-file it will not.
If I do it. What have you stated? Only that. What have you stated, madam, in your?
That was well. That 8.6. Make
That clause is depending
Fine.
on,
time stipulation so that they will do it. Otherwise, anytime.
Will
That is the process. in
Take
fact.
some time.
আমার কাছে কোনো ব্রিফ নেই
They have to make some regulatory provisions also.
কোনো
But
idea
why-
নেই।
Contempt.
প্রিয়াকে ট্রান্সফার্স বা সিদ্ধার্থটা পাঠাচ্ছি নিয়ে গেছে দেবজ্যোতিটা পাঠাবো
all right.
Item number 2.
My lord, may I beg to appear virtually for item number 2 for the appellant pilot? For the appellant, I am appearing, my lord. Kindly, I beg to appear virtually, my lord. My lord, in this matter, there is a delay of 4 days, and I have also filed an stay application. If your lordship kindly issue notice on that, and then we can come back. Otherwise, there is a delay of 4 days, lordship.
Let's see whether there is any merit in your review application of. Where is the order?
Lordship, in that case, I will request your lordship to keep it on reopening date or tomorrow itself, because virtually I think I won't be able to impress upon the court and I
Not
can
the way,
place it.
Mr. Counsel.
I'm very sorry, my lord. I'm
In
extremely
that
sorry.
case, this should be done. In this case, something else should be done.
I'm extremely sorry. my lord.
Requested on behalf of the petitioner, list this matter on 15th January. Yes.
I'm much obliged, lordship. Much obliged. Deeply obliged.
Copy of the application, the review application, then I can assist your person.
Today I will.
Till now, limitation has not been fulfilled.
Item number 3.
item 3, your lordship, we only stand to file a counter affidavit. We had sought for instruction.
You are seeking review of which order?
My lord, I am seeking a review of the order dated 15th May 2025.
Where is that?
My lord, page 20, my lord.
This sand case.
My lord, the sand case. I have also additionally filed an affidavit, my lord, to show that the illegal lifting of sand is still going on. That area. So that there is sought time for legal instruction. I'll submit. In the due course of the day, I'll submit.
Yes. So we stop it. Some resolution.
I'll also serve a copy of the additional affidavit.
As requested by learned AGA, is this matter on second week of January
My lord, it was third week of
or
January.
some third week of January. In the meanwhile, let a counter affidavit be filed in behalf of the state. Yes.
Why would I beg your pardon to mention matter? Well, the
My lord,
ex-chairman-
my lord, I want to mention here from the BC.
Recently,
My
the
lord.
rent officer is forcefully.
Give yourself.
My lord,
Bail application.
my
Bail
lord,
application, why are you mentioning here?
my lord, this,
Why are you mentioning here bail application?
because
Give your slip. Please give your slip.
WA 27, 25, 24, sir.
Eviction matter.
Two times sir mention किया है sir. Mention किया sir 27, 20 by 24.
Two times कब mention किया था?
Sir,
कब किया था?
next week किए थे sir.
नेक्स्ट तो आने वाला है और मुझे तो याद नहीं है कि आपने कभी मेंशन किया.
किए थे sir.
Give your slip.
Urgency but an order.
एडवोकेट मेंशन किए होंगे क्योंकि हम तो आपको देखे नहीं पहले.
Now he is staying it outside of.
All right.
Lordship, I may pardon to mention,
Sir,
I am in
Odisha.
virtual.
He is staying outside Odisha.
Outside Odisha.
अच्छा, देख ले.
Lordship, I may pardon.
His name is Ashok Kumar Pandey. He belongs to.
Give your slip.
I'm going to urgency. There is a sale option. If this case will not be heard, then my property will be sold on 7th of January. So that is the urgency, my lord. It may
Pardon to mention, my lord, item 21, my lord. I beg your lordship's pardon that request that the lordship may kindly call this matter second week of January because of the
Which matter?
21 of today's list, my lord.
You are appearing.
Yes, my lord.
We specifically it was for listed mentioning today.
No.
So
We had earlier intimated, my lord.
so at least I will finish my argument. I've come all the way.
Advanced I had intimated still then my lord is still pressing, my lord. Pressing, my lord. Inconvenience of the lord and AG, I am communicating your lordship that he will not be.
Yes, Mr. Grant, at least.
Second.
See, there are two things, Mr. Please appreciate this. Which matter is that? Item 21. Is this the case where the Supreme Court
Yes.
has fixed a
Yes,
deadline?
that's right.
That is very embarrassing.
Lordship, I may be pardon to mention, I am in virtual lordship.
Second week only one adjournment, lord. Second week of January, my lord.
Second week of January.
Second week of January.
Lordship, I am sorry to
Who
mention.
will be answerable to the Supreme Court? Who will be answerable? Huh?
It has come.
Let him conclude his argument.
Lordship, I may be pardon to mention, I am in virtual.
Let him conclude his argument.
Lordship, on elephant corridor case.
Let us see the order of the Supreme Court. If that is the case, then it is very difficult. Do you have a copy of the order?
It was hard and judgment was reserved. It was hard and judgment was reserved. and it has been released in the meantime.
Oh, there is no Supreme Court order. In fact, I was under the impression that there is a Supreme Court order.
It's like not.
But the order is here. 9 December 2024.
Appeal is allowed.
Yes.
Then what?
But the matter was not taken up by the court since the matter was pending in the Supreme Court. Supreme Court says no, your lordships can proceed and decide the matter. 9th of December 22. I'll place it when your lordships calls out the matter, and it's a fair via media. I can complete and he can do it on whenever your lordship picks
No,
up.
but what is the purpose? See, Mr. Jain, we would have heard you. But if Mr. Acharya is here, if we hear you today, and Mr. Acharya has to advance his submission in the second week, then what purpose will that serve?
With greatest of respect, second week I'm opposing your lordship. I had it on listed mentioning. This date was fixed in the presence of party. This happens on every occasion. When we are here, we are presented with the situation. And
Maybe
it's a 17-page matter.
Either he is trying to avoid you or the bench.
No, not at all. But he thinks that he will take a precedence over everyone. And every,
No, I'm on item 21.
Yes, I know. I'm sorry, Mr. Yes,
Your colleague
but
mentioned.
every matter, he's coming and mentioning keep it at 2 p.m. So that I can, will not every time accommodate him. It is.
I have not mentioned, I did not ask for 2 p.m.
No, we
His colleague mentioned that
day
I
before. To his junior that we have some difficulty today. Still then he insisted, no, I'll come. And I'll come and address the court. We intimated him day before.
Last time there was some
Yes,
problem,
Milord.
so we had asked you that.
Every time he's insisting that no, it should be taken up. As if his matters only are important for this court. But I'm sorry, it is quite embarrassing for me.
See,
Also.
Mr. Acharya, we are here.
That's correct.
If any unreasonable submission is made, we are here to deal with that.
Correct, Milord. I'm sorry.
So it is
Lordship, I am sorry to mention.
we are fixing cases to be taken up at 2 p.m.
That is correct. But every matter,
Client.
that's correct. That is, I
Lordship,
respect it. But
Lordship,
once intimate in advance that we have difficult period, I have 4-5 matters today to argue in different courts.
Lordship, I may be pardoned to mention. I
So
am in
when do you
virtual-
want? When do you want?
It's the 3rd week of January or 2nd week of January.
All right.
It comes 17 matter.
All right. All right.
So you
As
have-
Mr.
Not kindly, with greatest of respect, that's derailing the whole process. Your lordships, when we mentioned it was unlisted fixed for today, let me complete and he can take his turn.
No, that can't be done. I have
No,
to.
I'm not at my learned friend's mercy. I'm requesting the court. Kindly consider this.
I am also requesting the court. I'm not on your mercy also, Mr. Jain. Right? Understand? We must respect each other. We must.
What is this?
I'm sorry, Milord.
What is this? As if we are nothing.
No, Milord, I'm sorry. But he is accusing. I'm not. I don't have.
Lordship, I may be pardoned to mention. I am in virtual Lordship. Your Lordship may
is-
permit to mention on matter.
As requested by Mr. Acharya and Advocate General, list this matter on. 24th of January.
Any day continue, Your Lordship.
Lordship, I may be pardoned to mention one elephant corridor matter. Your Lordship has heard this matter 3 weeks before. Lordship,
Give you a slip.
Lordship,
Tender matter. We are saying that the tender would be completed and if it is not taken up.
Give you a slip. You don't know.
More in the last working day, will you request us to face that the admission matters, some matters may be taken up so that
Give you a slip.
we'll face that.
There's also provision that also that which your lordship reverse the judgment. Filing additional note, mining matter.
Give.
Lordship, I may be pardoned to mention. It is a elephant corridor matter, Lordship. Your Lordship has heard this matter 3 weeks before. WPC 14706/22, Lordship. Yes, Lordship. I am handing the physical copy of this memo, Lordship. In your Lordship court.
No, it is not. 14706. Matters under the heading to be mentioned, item number 1. WPC 66 of 2024.
This had been dismissed on 30th. Because some corrections were there, it could not be uploaded immediately. So that to prevent inconvenience to you all, we have got it listed today. It will be, judgment will be dated today. All right. Could not be corrected and uploaded on the same day or immediately thereafter. In order to prevent inconvenience to the parties, we thought it fit to list the case today at the heading to be mentioned so that the judgment will be pronounced today.
Matter the heading for orders item number 15.
The orders has already been complied with. I have filed a memo for withdrawal of contempt.
Yes.
Well, memo is like
Sorry, sir. Contempt application has been filed.
Uh,
21/11/2019 passed in WPC number 15086 of 2013. Stop. Today a memo has been filed by learned counsel for the petitioner stating that since the order has already been complied with, the petitioners do not want to proceed in the case and pray for withdrawal of the contempt application. Considering this said memo and the submission of the learned counsel, the contempt application dismissed as withdrawn.
item number 16.
16 by regulators, they have been elected 54 days in filing within the case. This is a case of moral.
We are issuing notice.
Since postal tracking report indicated that notice had been delivered on the address sheet, matter was directed to be listed on 9/12/2024. The registry had been directed to ascertain if any counsel has appeared on behalf of the respondent in the meanwhile. Full stop. The registry reported that no counsel has appeared on behalf of the respondent, hence the matter was adjourned on 9/12/2024. Today, when the matter is called, none appears on behalf of the respondent. In the interest of justice, issue notice to the respondent on the question of admission by registered post with speed post, returnable within 4 weeks. Requisites for which shall be filed within a week. Stop. The IA for condemnation of delay shall be considered after appearance of the respondent. Yes.
10th February.
Okay.
10th February. Item 17.
Similar interpretations are pending before this court. If you notice on the question of admissions. Yes.
Item 17. 17, my lord, there has been a delay of 222 days in filing the writ appeal. The question of law involved is, my lord, he was, the writ petition was regularized after 1/1/2005. So his prayer for getting GPF and other pensioners benefits in terms of that, we are challenging that also.
He had been regularized with effect from 5/12/2006.
Yes.
So by the time the amended pension rules had come into force.
That is the best.
Yes,
And for the opposite actor also filed the
objection.
the IMU. Last one, my lord directed to along with the similar matter. That matter is not similar.
This is not similar.
Yes,
What
yes.
is the number? Okay. No, we will do that. Similar number do you have? Mr. Das?
I don't have
The
that.
number of matters.
Number of matters are there.
What is the 222 days?
212.
How much money will you take if we condone the delay?
After during admission will be considered on merit, you can also make your submission.
Regularly with effect from 16/8/2005.
But you were regularized on 2006.
With effect from that.
With effect from
In the-
5/12/2006.
On the read petition annex 5, it was running page 13 in the read petition. The petition regular with effect from 16/8/2005.
Where is that? That order?
What is the cutoff date?
Cut off date, my lord, 1/1/2005, but that notification came into force on 17/9/2005.
So what?
As per the Anand Das case also, that has confirmed this.
We will consider your case. We are condoning the delay. 5,000. 5,000.
Minister Das, learned additional government secretary, and Mr. Satya, counsel appearing on behalf of the respondent. Given the grounds taken in the IA for condonation of delay and in the interest of justice. Although we are not satisfied that sufficient cause has been shown for condoning the delay, in view of the action of law involved, and in the interest of justice, we are inclined to condone the delay, subject to payment of cost of ₹5,000, the respondent within a period of 2 weeks. The idea of the delay is condoned, the delay in filing the appeal is condoned. The idea is accordingly allowed and disposed of. This is the case for fresh admission. Look at it. For fresh admission from 6/1/2025. Have you served a copy of the, you have a bill?
I will.
Copy of the writ appeal. Copy of the writ appeal memo shall be served on the learned counsel for the respondent by
Tomorrow.
by tomorrow. Yes. And just a minute. This one. The second matter, Mr. Das.
Ballot.
Mr. Soy, all right, your case we have posted to 6/1.
Second matter, since it is not similar.
No, just take a look. Similar, but as per your grounds, it is covered by a decision of this court in WA numbers 417 of 2021. Just take a look regarding that school matter. We can get it listed on some day.
You are appealing.
No, ma'am, I'm in this matter.
Next one. This is the one.
Oh, yes, your lordship is correct.
Covered by technical लाइन से आरटा लिखित है since sorry WA number 1610 of 2023 is not connected with this case and may be dealing from this case. First direct already. Now WA 1610 of 2023. As it was submitted, notice had been issued to the respondent of a question of condemnation of delay, full stop, on 9/12/2024. As the postal tracking report indicated that notice had been served on the addressee hyphen respondent. And it was also submitted that the case subject matter is covered by the decision of this court in the case of State of Orissa and others versus School Managing Committee of Amaramunda Government Primary School and another. Bracket white judgment dated 29/10/2024 in writ appeal number 417 of 2021. Full stop. So the case had been directed to be listed for fresh admission today. When the matter of question of limitation would also be considered. Full stop. However, the matter has been listed for orders. Full stop. Hence, list the case on 6/1/2025 for fresh admission. On which day the question of limitation shall also be considered.
As a matter of fact, identical matters, your lordship have already rendered a judgment.
That is probably that case. So next time, please get a copy of that.
Yes, ma'am. Yes.
Item number 18.
My lord, 18 noting that is our fault. Notice couldn't be issued to the sole respondent due to non-filing of the postal requisition. That is my fault, I was saying. That 2-3 days will be granted.
Mr. Rock, this is also not.
Fine objection.
No, item 18.
According to me, 293 days. They have shown 229 days.
Item 18, Mr. Rock, you are appearing in item 18 also.
18.
18.
I mean 18.
No, you are in 19.
18 also.
Oh, 18, his name doesn't appear in the.
18, have you filed a objection? देख लो appear करते नहीं आप ये टमाटर ये फंसले था ना इसलिए
I'm sorry, ma'am. I'm in 19. I'm sorry.
18, will file the requisites within 2 days.
Mr. Bimbisar Das, additional government advocate submits that prays that he may be granted 2 days time to file the requisites which inadvertently could not be filed by 8/11/2024. Full stop. Considering the said submission, if requisites are filed by tomorrow, 24/12/2024, notice shall be issued to the respondent by registered post. Notice shall be issued to the respondent on the question, respond on question of limitation by registered post with AD, registered post / speed post with AD, making it returnable within 4 weeks. List the case on
10th February.
10/02/2024.
Item 19.
This is known.
I find objection. You have received it. There is you have copy not served, but
No,
copy
it
has
has
been
not
served.
It has not been given.
Copy has been served. The receipt is with me. You collect it from your office.
Anyway, you tell us how you have explained the delay.
What is the delay?
My lord, delay is 293 days.
And what is the point?
My lord, the point is, they say that the honorable single judge has decided that the date of birth shown in the register is not correct. Accordingly, that was declared that the date of birth is to be taken from the date that has been indicated in the age entered in the service book. But they have challenged that. They say that when she entered in the service, she was not having the qualifying age, but she was taken in the transfer post. Thereafter, she was taken into transfer post in the regular process.
So let us see the order.
My lord.
Let us see the order.
Yes, ma'am.
Item number 18, 19.
19, ma'am. Order is at page 26, my lord.
I'm sorry, no, that yes, 26. The wrong reason.
The law, you will find the ordering person at page 46.
Just a minute. Yes. Which part, which part? Which paragraph?
My lord,
Ordering person.
there,
Paragraph
there to show it mine.
Our turn, it has been reflected in para 6. At page 31.
Or 26.
So what was it? Come to direction 10.2. What is there?
My lord, I'm sorry, my lord, that I was in a different case. Page 31 is the order.
You come, Mr. in the first week of January, you were in a different case and then again you.
Sorry, my lord, I
This is
thought.
where, the one post has been directed to be abolished and another
Yes,
created.
director be created.
We will take up your case on second, third.
Yes.
All right.
I'm obliged by it. I was in a different case.
No problem. It's Friday.
That is right.
Monday.
6.
FC current.
Item number 20.
Yes.
May I please ask?
This matter covered by a decision of this
By your
court.
lordship's
Yes,
judgment,
I remember the
there is a
facts.
judgment that they on
This
this.
probably was not brought to the notice.
No, he was brought to the
Brought.
notice, it has been taken note of.
Oh.
Then, my lord, the direction has been given to relax the operating limit by 6 years.
This has come for dispensing with the filing of certified
Not
copy.
for interim order, it's for orders. That's said, it was filed immediately.
Is there any IA?
Yeah, yes, there.
IA is there.
IA is for
IA
dispensing with
stay
the
of
filing.
implementation.
Yeah, item number 20.
Item number 20. IA is there, 2 IAs.
But there is
One
Two
for,
How much delay?
no delay.
no delay. Within 3 days, it was, my lord.
They had mentioned for a delay.
Yes.
May I please, your lords?
We are issuing notice.
Notice and stay of the implementation.
Stay.
Stay of the
Let us
implementation, because they will be asking my lord to participate now. And the process is for recruitment of constable and sipai in the special armed force. The honorable single judge says that you relax 6 years and permit them to participate. 39 petitions have been filed. We have also filed a writ appeal. I'm furnishing the numbers.
Just a minute. Where is the direction?
Your direction at 146 page, my lord.
It can't be 146 because 146
sorry,
is the earlier one. So it must be 122 or 23.
Load up para 51.
That 51 is.
Sorry, I'm sorry. Lord, I'm going.
No, that is.
I'm sorry.
That is the division bench.
Yes.
Which order you are challenging?
Lord, I'm challenging annexure 4 begins from 105. Lord, the direction is at page 122.
123.
22. The direction is being mirrored at page 121. One-time relaxation of the upper age limit for candidates would have been eligible had the recruitment process proceeded as originally scheduled. There was no mirrored schedule of advertisement earlier. This measure seeks to mitigate the impact of delays, ensure fairness to affected candidates. Consequently, candidates availing the 6-year age relaxation as per the cut-off date specified in the recruitment advertisement for the post of Sipai Constable shall be eligible to participate in the recruitment process. And not that a mandamus has been directed to consider relaxation, but the court assumes powers unto itself and relaxes the
Which post is this?
Sepoys.
Sipai and Constable. And it says special force under the Police Act.
Is it contrary to the revision bench decision?
My lord, your lordship may, two issues. First of all, the rule upon which he relies, upper age limit, etc. That doesn't apply to a rule which has been framed under a statute. Police Act 61, your lordship knows it is central law. Section 2 empowers the state government to make the rules.
There is no Odisha Police Act, no?
No, it's a central act.
No, all the states have.
No, they were contemplating, but there is no Police Act, state Police Act. So, the general rule-making power is given to the appropriate government under Section 2. So, set of rules have been framed. That you lordship would find at page, in the counter affidavit we have filed at page 60, your lordship would find the rules. Your lordship can have a glance at the rules, That page 60, that was a part of our counter affidavit annexure A by 4.
This has not been brought to the notice of this court. I don't find any mention in any of the paragraphs. The judgment, the earlier decision of the division.
No,
bench. Please show which paragraph. May have missed, but please show it. How has it been dealt with?
That was argued. We had also filed a detailed.
No, is it there in the judgment?
Yes, it is there,
Just please, sir, I was not able to find it.
You lordship would find. But
It is not there in your submission. Manoranjan Sahu.
That might not be there.
It is there. The Manoranjan Sahu. Yes. Yes. Has that been discussed?
No, that has not been. We relied upon. That has neither been distinguished nor mirrored.
All right. So, but that division bench decision that has not been challenged in the Supreme Court, it still holds good.
Yes, that holds good. That has not been. Yes.
The state of Odisha has to challenge an order passed by learned single judge, a judgment passed by a learned single judge of this court, dated 5/12/2024 in WPC number 26079 of 2024, racketed Biseswar Biswal and others versus State of Odisha, whereby in the matter of recruitment to the post of Sepoy in Odisha Police, the learned single judge has directed for granting a relaxation in age by 6 years on the ground that the recruitment process was not conducted for 6 years.
For 18 days, for 6 years.
For several years. For various reasons, including COVID-19 pandemic situation. And in the meanwhile, some eligible candidates became over age under the rules regulating such recruitment. Next, Mr. Acharya and Advocate General has argued that the direction issued by the learned single judge being contrary to is not only contrary to the statutory rules framed in exercise of power under section 3(2) of the Police Act 1861, but also in the teeth of a division bench decision of this court in case of
Manoranjan Sahu versus.
Manoranjan Sahu. Is that reported?
That is. But I'll check.
Manoranjan Sahu. Where is which paragraph that is mentioned?
In an annexed here at case 124, you will also could find that judgment we have annexed.
In case of Manoranjan Sahu and others, rendered on 27/6/2023, rendered by division bench, and so in WPC number 2721 of 2023 and batch. So stop. After having we are prima facie satisfied with the submission advanced on behalf of the by Mr. Acharya. इसको notice पहले कर दो, आइए. In the meanwhile, the operation of the impugn order shall remain a state. But what about the process of selection?
Process of selection, it is.
If the stay
examination is complete, by virtue of an interlocutory order, we permitted them to participate, but results are not out.
In fact, the learned single judge has stated that they will not be appointed unless they participate in the physical tests and come out successful.
No, that is different. Suppose they come out successful and again got selected for some reason.
Okay.
That would be also a disturbing thing.
So they have appeared in the
written examination.
Okay. By virtue of an interim order.
Interim order. So this is the final order.
So final result. Maybe so. But other recruitment has taken place.
No, this is for post of 2,000 Sipais and constables. Around 2.5 lakhs have participated.
Mr. Acharya, the best way is to expedite final hearing of the of this appeal,
that is correct,
because otherwise your entire recruitment process is stuck up.
That's correct, Millard. Your Arshik may fix up a date in the first week of January. Number one. Number two, Millard, in the meantime, number of cases are also being filed that you extend this benefit. And the Honorable Court is insisting that you conduct a special examination.
Because of this.
Because of this. So that would be that.
Does this case on? Date fix karo, second week of January. 13th. 2 p.m.
Order, Millard, so far this judgment is.
No, but you have conducted the process of selection. You are
Not final. Only detailed examination has been held, but results have not been published. Your Lordship may say the results of those candidates who are permitted may not be published.
It is observed that in the meanwhile, Mr. Acharya has submitted that in view of this court's order, which is judgment which is impugned in the present writ appeal, the candidates who had crossed the age limit have been permitted to participate in the process of selection. But in the process of selection,
Written exam. Yes.
process of selection, and they have appeared at the written examination. First off, we make it clear that final result shall not be published in the
In
meanwhile.
respect of those candidates. In respect of those candidates.
No, but in respect of those candidates, if you don't publish, see, you don't publish any result because you don't know how many of them might have qualified on the basis of merit. So you see, suppose there are 100 candidates who are overaged, but in the merit, they rank higher. So if you exclude them and publish the result and if you appoint them, then what will happen?
But that is a different question. But here the question whether the age can be relaxed in violation of the statutory rule.
That we will decide.
Yeah, that's correct. So, the non-publication of the entire result would be then again. Your Lordship may say impugned or judgment shall remain state.
All right.
Judgment shall remain state.
Yes.
Let the second part of the order may not.
Yes.
During the first week of January.
13th.
But may I say that other details are also there are 39 details.
Give the number. Mega mention so those matters will come in the first week of January. No, not along with that, because in this case we have issued notice. In those cases, no notices have been issued. So make a mention tomorrow. This bench is not there.
So in the first week,
make a mention on second or third.
But I'm sorry. In fact, I came running, so I became sorry.
Sir Acharya, see, when any lawyer appears before this court, there are so many things in the mind.
That's correct.
Including convenience of a counsel. It may appear, and I also feel about this, that sometimes we give undue preference to the lawyers appearing from outside. Supreme Court, like and in one of the cases I had remarked that because of you, so many cases could not be taken up, and therefore you should compensate by depositing something in the. Therefore, so if someone appears and he is put to inconvenience, then that is there in our mind. And you are Advocate General, you are
3 days before.
You are first law officer of the court. We have to accommodate you also as and when required. That is that. That is that.
Damn sorry.
Item number 2.
Already in the meantime, the medical board already approved the case of the petitioner, and I have some instruction. University also received that medical board report. In the university intimated that the next board of management meeting of deputy will be held soon, An intercollect transfer of Bhagyalakshmi Mahal will be placed as an agenda item in the above meeting. Further, it is to intimate that original NOC issued by the Synergy College already received by the university. The next agenda should be placed. Already is.
We will not dispose it off.
Fine.
Mr. Nair, Mr. P.S. Nair, and counsel appearing on behalf of Biju Patnaik University of Technology, Odisha, Rourkela, has submitted that he has received instructions to the effect that the petitioner's case has been recommended by the CDMO, Cuttack for inter-college transfer from SIET Denkanal to GITA, Bhubaneswar on medical grounds. Stop. Further, the next meeting of the Board of Management of BPUT will be held soon when the petitioner's case for inter-college transfer shall be placed as an agenda item. So stop. The original NOC issued by the SIET Denkanal has been received in the university on 16/12/2024. Stop. Next. List this matter on third. Within first 5 cases for cases. Stop. In the meanwhile, Mr. Nayak shall seek further instruction as regards sixth within first 5 cases. First 5 cases. Let us see what happens.
The submission item number 3.
My lord, the petition was disposed of in the light of another order. Your lordship will find that order that has been entered in the writ appeal, that is writ appeal number 557 of 2022, which is pending, where an interim order has been granted. So this case, which has been disposed of in the light of that judgment, which has been assembled in WA number 557 of 2022, which is pending. Now, my lord, no purpose will be found here. But no purpose will be achieved by taking up this case.
No, what happened in that case?
Let me see
the
in a recruitment process.
The next year, where is the impugned order?
Impugned order, your lordship will find at page
47.
Yes, my lord, it starts from 47.
I am for the respondent.
Your lordship will find one page order, paragraph 3. London Council for the petitioner states that the claim of the petitioner is fully covered by the judgment dated 15/9/2000.
So what happened in Satyabrat Nayak?
That has been assembled in writ appeal number 557 of 2022, which is pending before your lordship.
So let it come along with that.
That's what my prayer was.
This matter, an order dated 10/1/2003. Much. What is this that about? Satyabrat Nayak?
That is, my lord, the upper age limit was 32 years in a recruitment process, which has been announced to 42.
The
Upper age limit.
Yes.
An order dated 10/1/2023 passed in WTC OAC number 2235 of 2017 is under challenge in the present writ application. Present intra-court appeal. So stop. By the said order, the writ petition has been, by the impugned order, the writ petition has been disposed of in the light of the decision rendered on 15/9/2021 passed in WPC bracketed OSC number 902 of 2016 bracketed Satyavrat Nayak and others versus State of Odisha and others and batch. Stop. The said order dated 15/9/2021 in Satyavrat Nayak bracketed Supra is under challenge by filing a writ appeal in which judgment has been reserved.
Yes.
Post office. List this case on who is appearing. Issue notice. Issue notice.
No, he is appearing.
Notice
He is
You are appearing.
Yes, madam.
All right.
Notice
Then,
I have received the copy, madam.
All right.
all right. Issue notice. Mrs. So has received notice on behalf of the respondent. List this matter on third week of first game. 13. 13.
13th of January.
Item number 4.
Item 4, the respondent, I have already received the copy of the writ appeal mail. So 3 weeks time may be given and finally the objection to that.
Objection to what?
The writ appeal.
Writ appeal.
Writ appeal, there is no.
And another point, the delay has been condoned. As per your lawsuit direction, they have to pay 2,000 to the.
Cost we have already paid to the party man. That has already been paid.
But no receipt, they have only.
Yes, ma'am.
Online payment has been made. to
If
the account it is
receipt
deposited.
had not been there, there would have been a notice.
For that, I will file a minimum objection.
Objection to the writ appeal.
So that the criminal case is.
This is regarding my field cover procedure.
98 criminal
Already
cases.
You
decided.
can seek adjournment, but not for filing a. When did you receive notice?
December 7th or 8th.
Then we are in January. We can adjourn it, but
You have appeared on
As per the
November you have appeared.
Yes, they have,
Yes.
as per last order, madam, directed him to solve a copy. And they have solved a copy of the writ appeal. We have to.
No, on 2/12 you had wanted time to get prepared in the case.
Yes.
Yes.
So that, by
Not
that,
for
no
copy.
appeal petition was there in my.
No prayer for copy.
when counsel appearing on behalf of the applicant seeks adjournment. No, sorry, the respondent seeks adjournment. So, let's this case, third week.
Item number 5.
My lord. Here in this case, my lord, the single judge disposed of the writ petition, directing for regulation of service of the writ petitioner on the basis of the judgment rendered by the Supreme Court in the case of Kumadevi. ML.
Let him, yes. You can't, let him say what he's saying. He is the petitioner.
Here, my lord, we didn't get any opportunity to give a reply. Secondly, my lord, unilaterally, the honorable court held that the petitioner was holding a sanctioned post. As a matter of fact, there is no sanctioned post, which is a requirement in terms of the Kumadevi judgment. The post must be sanctioned, vacancy must be there, and 10 years. My lord, here, there is no sanctioned post, and all the respondents, they were posted on DLR basis after the cut-off date. Your lordship knows that 15/5/1997 circular of the state government, where it says that 12/4/1993 is the cut-off date. Thereafter, no appointment can be made. That was the main period. During that period, after 12/4/1993, all the respondents, they were appointed.
Yes.
And they were working for 25 years. They were working for 25 years. Huh?
Around that, exact.
Banki NSC.
Sir, yes, sir. Baki
Oh, you have to.
In the impugned judgment, my honorable single judge has taken note of the fact in page 2 that in identical matter, the state went to the honorable Supreme Court, lost it there. It cannot be treated to be an identical case because
Mr. No counter affidavit was filed. It was disposed of on the very same day, first day. No notice was issued.
Which but number 4 NSC.
Huh?
I am not the petitioner.
So he appears for the NSC, he has no objection to the condemnation of the last time.
Who is appearing for
Nobody
it?
is appearing.
The name is wrongly reflected as Mahaman Singh. That is
In the second application.
the first one did that.
No,
Counsel for the petitioner was appearing. The name was wrong in the title.
no, not name. We are saying that has notice sufficient on the parties.
So that he is not appearing also. Due to his name is wrongly. His name Vidyadhar Mahat is reflected. Actually, his name was Vidyadhar Mahaman Singh also. Mahaman Singh also. So that he could not be
Mahaman Singh or Man Singh?
Mahaman Singh.
B. Mansingh.
B. Man Singh. It is correctly noted in the second one. First one, it is what is your name, please, Mr. Sahu?
Yes.
You are Mr. Sahu. Okay, and this second writ appeal name is reflected correctly.
All the cases were disposed of on the same day.
Yes. Lordship in one writ appeal 108 of 2024
It has appeared.
passed an order taking out of the High Court rules that without giving notice should not be. This case can be taken up.
First one reflected incorrectly. Second one name is there. Should have appeared. But today nobody is appeared.
There is no representation on behalf of the contesting respondent number.
Respondent number 1, 2, 3.
1, 2, and 3. Though publish this matter on second week.
Yes.
Second.
Judge.
So same matters or common order is all right. Both can be listed together.
Yes.
Common order together. Just one line that in the first writ appeal, name of the counsel for the respondent has been mentioned incorrectly as Vidyadhar Mahanti in place of Vidyadhar Mansingh. Very correct. And will be correctly mentioned on the next day.
The Lordship kept it to 2nd of January.
6th.
Item number 6.
Not for the first time it is coming. He may grant me 2 weeks time to obtain instruction.
Okay, the matter of on third. Validated take instruction third. Already payments have been made. Now demonstrate the slate.
If this is scale payment below, I will obtain instruction and will also file complaints.
10th.
Similar matter.
As requested on behalf
Similar
of
matters are on 10.
the opposite parties. List this matter on as requested by Mr. AGA and counsel representing the opposite parties. List this matter on 10 so as to enable him to seek instructions
Right.
and file compliance application. Nine.
Number 9.
9. Right.
Item number 7.
7, your Lordship, kindly see order dated 2/12/2024.
But annexure A/2, order date 10/12/24, the appeal was disposed of. My appeal was disposed of by the order date 10/12/24 as per the annexure A/2 in the
Your Lordship,
He's the appellant. Petitioner. Item 7. You are the petitioner.
Yes, as per the affidavit of the suffer letter, opposite party not 2, annexure A by 2, my appeal was disposed of by the order of 10/12/24. I petition now rendered instructions because my prayer was to challenge the
petitioner states that this writ application has become infructuous in view of the developments subsequent to filing of the writ application. So the application stands disposed of accordingly.
I will challenge the set.
The petitioner shall be at liberty to question the correctness of the order passed in
Tauji case number, TZ case number 4/28, yes, 18. I ordered it 10/12/24.
Before appropriate forum. Yes.
Item number 8.
After the value period, the extended day, I remember lecture last week.
Yes.
19/1/2024, my lord, the notice inviting proposal for outsourcing.
Oh, that we had heard.
January 2024, my lord, notice was invited for the outsourcing mechanism laundry services to supply bedsheet at government health institutions in the district of Parayandi. That is my lord, Annexure 1, page 12. Then the date of submission of final, technical and financial bid was the 13/2/2024. On 13/2/2024, my lord, at 3:30 p.m., technical bid was opened as per their own counter. My lord, the date of 180 days completed on 13/8/2024.
Yes.
Then we informed, saying that on 13/8, saying that already it has been 180 days has already been completed as per 2.6. So its loss is forced, you have to go for fresh tender. But on 23rd/8/2024,
yes,
they requested all the bidders, give your consent, we are extending 45 days. Then, my lord, on 27/8/2024, petitioner, my lord, submitted his reply that not to extend the dates, 45 days. Then 20th/9/2024, we received a letter from the opposite party now 2 that the financial bid is going to be opened on 27/9/2024. For the first time, my lord, we came to know that we have disqualified out of 8 bidders, 6 has been disqualified and 2 has been selected. At no point of time they have disclosed who have been qualified or disqualified. For first time on 20th/9/2024, they disclosed. That is Annexure 5. That is to the repression. On 17/10/2024, they executed the agreement with the new bidder, but it has not been there in the counter. On 18/11/2024, the counter has been filed by the state. It was not there in the counter. Subsequently, in the additional affidavit 3/12/2024, they have come up saying that inadvertently we have missed it.
Inadvertently we have
missed it that this part we have not submitted in the counter. That is in the additional affidavit they have stated.
That agreement has already.
That agreement they have executed with the. On 17th, they have made agreement, they are saying. But 18/11/2024, they filed the counter, served the copy on 19th, nothing has been mentioned about that.
And something you were saying that document has been procured from some other
Yes,
district
yes,
and
yes.
old document also.
Yes, madam, from Koraput. That document, that agreement paper has been purchased on 10/10/2023 from Treasury Koraput. In fact, on verification from that stamp vendor, he is saying that no stamp paper has been purchased in the name of the signing laundry on that day. If Lordship can, I can file affidavit from that stamp vendor also.
No, 18/11/2023.
23. Paper has been utilized here.
This is relevant.
Beyond that also, my lord, Lordship see that the execution has been made on 43 1 kg linen bed sheet, mean 2 bed sheets. They have executed 43 rupees 51 paise. Where my price was 17 rupees 75 paise. And my technical bid was rejected on the grounds the so much of cancellation of the GST. But their own eligibility criteria says you must have a GST number. I can show that again. That's you see. Please, Bellu, sir. And I'm proposing 17 rupees 78 paisa for 1 kg, 2 bed sheets. They have executed 43 rupees 51 paisa.
Yes,
Lordship, these are essential
we are just coming up.
Full bench matter, you will lot of arguments.
Yes.
This was an essential service matter, your lordship. There was no interim order as to say the signing of the agreement. It was subject to the result of the writ petition, your lordship. They had signed the agreement, your lordship. The person has started to work, and he has been also written that this his agreement and his contract will be subject to the result of the writ petition.
So does this require any inquiry by some independent?
Lordship, it was a technical,
Agency.
it was open, your lordship, only because of mode of election, your lordship, because of the election. So that 180 days lapsed, your lordship. Then fairly the tender committee took a decision.
No, but
that
why
it's
was that
extended.
not disclosed in the counter affidavit?
Your lordship, we have explored in the preliminary counter that it's a tender committee. They took a decision.
No. Regarding execution of agreement, why did you not disclose? Though we might have made it subject to tender, but subject to final decision.
Yes.
But you are supposed to disclose what has happened till then.
It was an inadvertent mistake because, your lordship, it was signed by the CDM.
It doesn't seem to be inadvertent because the old papers have been used.
Because the lordship,
Normally,
the CDM
stamp
signed the
papers of
agreement.
another district are they used for agreement? Unless for whatever reason you want.
But your lordship, the decision was taken by the tender committee that 45 days should be extended. They have fairly notified all.
Can you extend it beyond the validity period?
Because your lordship, even for
No,
a day.
I'm just asking, can you do it?
Because it was because they
I'm
were
not asking because.
the tender
Maybe.
committee took a decision, your lordship, and the authorities followed it, your lordship. That is all. And because this is an essential service, even for a day, your lordship, even if for a day,
But,
the things are not clean, and then hospital would come, all the work in the hospital.
That
would come
is-
to the
that is
staff.
it.
But I thought he was continuing. There was a status quo order. He was continuing to supply, if I am not
There was
mistaken.
no status quo order, your
Yes,
lordship.
status quo.
That was subject to the result of the
That is
petition.
That is past.
Afterwards, your lordship.
We
After
were not aware. You had not informed us about signing of the agreement. So that is why the date is important.
Had been signed before the.
That is why the date is important.
Your lordship.
And you are not disclosing it becomes important also. I mean,
Yes.
whatever.
Yes, your lordship. Because your lordship, the agreement was signed by the CDMO, and this counter has been filed by the medical superintendent, your lordship. That was because he said that
Yes, you have to have.
An invitation to offer made in this tender, and the offer has been made for consideration of the offer, the validity is required. Now, for the intervening election or otherwise, that as explained in the counter, they gave the fair chance to all bidder. Now, somebody opted not to file a fresh validity of the extent their offer means he is opting out of it. It doesn't. And so far as lordship's query is that whether it can be done or not, there is a general terms of 4.10 at page 34, which says modification in terms of reference, including the scope of service, can be done with the consent of the parties. So, my
There is no question of consent of the parties.
That is after.
Please read that again.
Well, my case is that
Where is that? What
Can't rely
clause?
on that.
and I'm not relying it. I'm just general clause at page 34, 4.10.
Yes.
Modification in terms of reference, including the scope of service, can only be made by the district authority. Institutions with written consent of both the parties. However, basic conditions of the contract shall not be changed. So here there is no change in the basic condition of the contract.
Relates to the party with whom you execute the contract.
Yes, madam. That's
Yes.
agreement. It was
Exactly.
the terms of reference is starts from section 3. But people otherwise, madam, that 2.6 which we have relied, the proposal shall remain valid for 180 days from the date of bid opening. Any proposal which is valid for shorter period shall be rejected and non-responsive. But it does not restrict the power of the authority from seeking an extension fairly and transparently. They have asked all the bidder to extend it. So there is no restriction reverse that they cannot extend it. And the process is
Our
that
question is, can you extend it beyond the period of validity?
they have
Within the period is okay.
the offerer is the tenderer. The offer they have
All
made,
right.
that remains valid for 180 days.
We will-
The request was made that you have to extend it beyond 180 days. If they
Yes.
opt not to do it, and there is no malafide or
Only thing which I had to point out is page 15, the eligibility criteria. The last criteria is that you must have GST registration number.
That's
So, but
needed, and if
that is one thing.
One at a time, one at a time.
In my counter, my lord, which is a social organization organized by these scheduled tribe persons. In the counter, my lord, I have given that as Annexure 8, that my GST number, my lord, having the number is dated 21st/9/2017, I have the GST number.
Maybe having, had you
Yes.
given it?
I have Annexure 8.
Had you given it?
I have given it. I have given it. They have cancelled, lordship. See, they have cancelled my technical bid saying that on the ground, lordship, see the Annexure 5, page 70. I am the 6th person. Janakalan Parishad Baripada, disqualified. GST is cancelled so much. From where they have got it? I have given the GST number. They have said that you have to provide the GST number. I have provided the GST number. Even, lordship, see the page 40 of that.
So why that number was cancelled?
I don't know, my lord.
No, they have.
They have to answer it.
What do you mean by GST suo moto cancelled? You must have mentioned in your counter, or again additional affidavit. Again additional affidavit will be required.
In the tender bid also, they are also saying that copy of the GST registration certificate you have to provide. Technical bidder, they are saying that page 40, the copy of the GST registration certificate has to provide it. So I have provided the GST registration certificate. Only stumbling block is that my price is 17 rupees 75 paisa, whereas they have executed the agreement 43 rupees 51 paisa. 1 kg Lilium bedsheets means 2 bedsheets. Let's see, we can consider that part. For what reason they have cancelled?
GST number so much to cancel.
Yes, madam. GST is cancelled so much. Annexure 570.
No explanation in the
Nothing
counter
has been
affidavit.
Annexure 5.
Annexure 5, lordship, see page 70. Dated 29/2024. For the first time, all we came to know that we are disqualified. Technical bid, in technical bid. They never disclosed these things.
Yes, how do you explain that?
In the tender bid, they are saying that GST certificate has to be given.
Annexure?
Let's see, Annexure 1 is
No, cancellation.
cancellation, that part that they have given.
In the
Annexure 5,
preliminary-
page 70.
7.
Out of 8, 2 has been qualified.
No, you are referring to which document?
Well, the Annexure 5, page 70.
Yes.
That is the serial number 6. My name, Janakalan Parishad, disqualified. GST is cancelled so much. Whereas in the tender documents, eligibility criteria, let's see, page 15, they have stated that in 12, plus 12,
All right, your GST is cancelled.
Running.
So your GST is cancelled as mentioned in this 29/2024.
Agree.
So what is the basis for mentioning this?
I have no idea. They have to say because as per their own tender documents, let's see the page 15, the eligibility criteria.
Let an additional counter affidavit be filed on behalf of the state opposite parties, stating the reason why quote unquote GST is cancelled suo motu has been mentioned in the 5th column of the table in annexure 5 to the writ application, which is the basis for declaring the petitioner disqualified in the technical bid.
In the technical.
So stop. It is the petitioner's specific case that a requirement of furnishing GST number was a condition precedent for participating in the bid process in question, and accordingly the petitioner had submitted the GST number.
Yes.
So stop. List this case on 4th. Oh, 6th. Let the counter affidavit, the additional counter affidavit be filed. By 2nd, you can do it. 2nd or 3rd?
Why for?
Huh? When?
Your Lordship, if it is placed on say 7th or something.
It will come on 6th, but you should file your affidavit before that.
Yes.
Or if you want more time, we can consider.
Okay, Lordship. Around 9th, if the 9th, then we can file it for 6th.
9th you will file.
6th.
9th के बाद कौन सा है? 13th. Additional affidavit must be filed by 9th. Oh, stop. The interim orders I will continue in the meanwhile.
And when you are continuing?
I am continuing. Yes, I am continuing, madam.
Okay.
Intervention application will be allowed to be directed.
IA number so this application has been filed for intervention on behalf of the successful bidder.
Yes,
I have to explain where you got that stamp paper from.
That's
not. If you become
let
me take care of that.
considering the facts and circumstances, this application is allowed. Let the intervener petitioner be pleaded as opposite party number 3. The newly added respondent shall be at liberty to file a counter affidavit dealing with the averments made in the petition and the rejoinder filed on behalf of the petitioner.
Item number 9.
It's about challenging the rejection letter of the DMT LLC at page 14.
Rejection for what?
Your Lordship, it was for
NOC.
renewal of the institution for the course of.
Which page?
It's page 48, Your Lordship, annexed 12.
Yes.
Lordship, by citing the subject WPC number 20418 and WPC number 20191 of 2024, they have stated in that letter that with reference to the subject cited above, I am to inform you that on scrutinization of physical inspection report dated 28/11/2024, it was observed that the infrastructure teaching block currently is inadequate to run the GNM and BSc nursing program, Your Lordship. But Your Lordship, if you will see the inspection report is page 42 and it's at 12. Relevant portion at page 44, the remark column, they have clearly mentioned that infrastructure are available for running ANM, GNM and basic nursing course it's sufficient. All equipped labs are also available. All classroom are also sufficient for
What
students.
can be done now? Academic session is over.
No, Your Lordship, there is time, Your Lordship.
Where is the time? Time is over.
Mahanti, what time is there?
Time is over. And they will be filing their counter affidavit.
The only thing is that
One,
there is, when there is the only defect of this final basic inspection report says some were not adequate buildings. So I don't know why they are rejected.
Means adequate building is there.
Building is there.
Huh.
They are telling that some square meters are not available. But previously that was given, that is what it is saying.
File your affidavit.
Yes, but
Does this matter on? Issue notice, so accept notice on behalf of DMET. List this matter on 4 weeks. So as to enable Mr. Mohanty, learned counsel for the DMET to seek instructions and file counter affidavit.
What was the last date?
last is over. Actually, only the date is there.
What
If
date?
if they have admitted students of institution, that can be up to 15th of January. But this is the LOC has not been given, so he cannot get admission.
And there was no, there were 2 earlier writ applications, so there is no order that he is permitted to admit.
No.
Okay.
that was only for the inspection of the institution, Your Lordship. And Your Lordship, if you will see the page number 46, they have allowed my A&M course in my institution.
Whole program is 29, they have rejected. 31st was the last day.
Yes, item number 10.
There are 47 applications, my lord. We have complied in 30 cases and 1 case we have rejected, and in other cases we are working for compliance.
Which have been complied with?
So that list I have supplied to my already.
Yes.
Yes, yes.
List.
Sanction order has been already passed, issued, and only the amount is to be credited to the account after verification. We are verifying the accounts of the person concerned, to which we will credit the amount. Sanction order has been issued.
We have already received the 12 numbers of companies, already received.
And other
Out of the
other we have listed. People will also can have a glance. My lord.
Then you have come to that.
10 and 20, another listed 20.
When was the order passed?
The date mentioned, my lord, in the right hand. Right.
You given 2 letters.
2 letters and 3 letters, my lord, in fact. 1 we have rejected, 1 we have rejected. One contains 10 list of 10%, and the other letter contains a list of 20%.
Yes, 20 you want time to comply.
Yes,
And where is the rejected one? That is not there.
rejected one is there.
Another one.
Another.
Yes, you give your list.
Yes, sir.
Where is your list? In how many cases the order has been complied with according to you?
12 units. 12. I have already received the complaints.
Received.
Yes, sir.
So which are those cases? Can you give the number?
Yes, sir.
He has given you a list of 10. So which are the other 2?
Which are the other?
Taku ଦେଇଛନ୍ତି ତାଙ୍କୁ list?
ନା ଦେଇନାହାନ୍ତି କପି ଏକ୍ସଟ୍ରା ନା ସେଇଟା ଦେଇଥିଲି
ଓ ସେଇଟା ଦେଇଦେଲେ ଏବେ ମୋ ପାଖକୁ ଆସିଲା ଏଠି କୋର୍ଟ ଇନଷ୍ଟ୍ରକ୍ସନ ମୁଁ କଣ କରିବି ସପ୍ଲାଏସ୍ ଚିଟ୍ ଗୋଟେ ଦେଇଦବ
I don't think how is 17 not sure that they want time to comply.
Can you give the number?
Yes, sir. I also give the number, Your Lordship.
Why are you not giving?
List. I also, only 5 minutes, I have prepared a 12 numbers of list and
Just give it.
What 5 minutes?
5 minutes.
Contemplating on behalf of the
Summation 17.
petitioner states that this court's order, violation of which has been raised in the present contempt application, has been complied with. 12 cases ka alag alag.
Yes, by mistake.
No, I'm looking for the sub-item 17.
Yes,
The order has been complied, so for me to withdraw.
very good. Are you giving us a memo? Double 561 of 2024.
Yes, yes.
You are Mr. Misra or you are,
Jagdish Sahu, J Sahu.
what is that spelling?
JGADIP
Look, have you seen the cause list?
Denominator.
No, it will be SAHOO.
Yours.
So another one has.
But how do you explain? The order was passed in November 2023. We are in December 2020. And in these cases, estimates submitted to DOWR wide office letter number so and so.
Must have been disposed of and this was the estimate.
Acha. Oh,
No, estimate, I believe the High Court must have passed the order and seen the estimate that in place.
according to see, you have a list of 20 cases, 10 cases.
10 and 20, 30. 10 already sanction order issued. 20 sanction order will be issued on the strength of that estimate.
How does no typographical error in your list? 5, 5, 6, 7, 7.
Lordship, may grant 2 weeks time, I will file an affidavit to that extent. In which cases, in the meantime, probably in 2 weeks, we will comply everything.
Do it.
My lord. I'll file affidavit.
Some of the cases are not covered in both your lists.
16 cases are left
Neither
out.
of your list do not cover.
16 cases, we have not listed that. Yes, I say, I admit, because 47 cases are there. We have only listed 31. So another 16 cases are.
You have listed 31.
Well, I've been reflected.
Another one is withdrawing.
Yes.
Not 47, Your Lordship.
Yes.
46. Out of 47, one list.
Yes.
My friend.
Withdraw.
So only 46 before Your Lordship, 46 is only for company.
So we will
land action.
take up these matters at 2.
You
All
give
right.
us- you give us
In
your-
the meanwhile, just tell us in how many cases the order has been complied with.
Yes.
In how many cases the order has not
Only
been
5
complied
minutes I will provide the list manner.
with. We are giving you more than 1 hour.
2 p.m.
Obliged.
And when we take up the matters on the next day, please ensure
Yes.
that all the orders are complied with. It's a very
Definitely.
serious matter.
Definitely, I will ensure. Yes.
Item number 11.
Item 11, appearing on behalf of Mr. Adeval. I am filing a memo to for withdrawal with the liberty.
Complaint.
Not complied, I think your lordship they are pursuing different levels.
Partly complied with.
Yes. With the liberty of the public. Appropriate
Yes.
steps.
Item 12.
Obliged.
Okay.
Sir, postulates.
Yerus Agarwal.
Learned counsel appearing on behalf
I am
of
Abhijit
Chief
Agarwal,
Justice
but
permission to withdraw this application with the liberty to pursue his remedy before appropriate forum. The contempt proceeding is blocked with the liberty as sought. Yes.
Obliged.
Behalf of Subhamma.
Non-commerce order by the minutes.
Item 12.
District magistrate minutes. Was more one minute. There is a direction to minutes comply the order within 6 minutes.
Which this is item number?
12 minutes.
12. You are AO cum divisional manager Canara Bank.
Minutes.
What was the order?
Order to dispose of the section 14 petition matter section under the sufficient minutes regarding taking the physical possession minutes, but they have not yet passed any order there. But that is I filed complaint petition minutes.
And the contemnor has left that place and come here.
But supposedly they can also pass minutes.
Let us see the order.
At page 23 minutes. Paragraph 5 minutes, 24. Keeping in view the submission made and going through the arguments taken in the writ petition as well as the documents annexed thereto, we dispose of the writ petition, directing the opposite one to take up the application section 14 of the sufficient for consideration and pass approved order in accordance with law as expeditiously as possible, preferably within a period of 6 weeks. Hence, we, the position of law as regards the scope and jurisdiction in the matter of an application under section 14 of the Act and power conferred thereunder as have been set up, rest in case of Mrs. R.D. Joint Company and Capital First Limited. But they have not yet made part. That is my grievance.
That side was not heard.
But only to dispose of perhaps. There is a direction to dispose of the matter. But they have to dispose of.
File your reply. Let this matter on 4 weeks. So as to enable an AGA to seek instructions and file an affidavit as regards compliance of this court order.
39 14 are similar. 39 14 are similar.
13, 14.
14. Okay.
For admission, item number 22.
Mr. Das, this matter is of Mr. Das.
Yes. Yes, what is this matter about? What do you want?
Mr. Das, they did a pass over matter.
I requested on behalf of the appellant, just this matter on 6
Item 23.
23 matter.
Same matters.
Regarding reversion of the judicial officer, we have not filed counter. I have written to them and I issued for which come. Let it come.
Registry of this report was, in fact, notice was issued way back on 2023. The register, when you are working as a registered general here, the proceeding was initiated in a very unfortunate circumstance. If I lordship permit me, I can face, but let them file a counter, fix up a short date so that matter can be disposed of at least before 18th, so that you also can.
Another matter is of the same petitioner. There also his notice has been issued, they are not filing counter. That is
hard analogous. In fact, that matter has not come. But a common counter also necessary. Let them file counter separately. We have no objection. But also fix up an early date so that it can be disposed of. I only saw that procedural error, natural justice violation, and the manner in which it has been disposed of. And a person he has been reverted not only back to selection grade, but for 5 years he cannot be also given permission to be.
Yes, when will you file affidavit?
After vacation, it let it come. Any day after vacation, we'll file in meantime.
Matter is pending since 2023.
No.
And they are right that
yes,
the matter is very urgent, should be urgently heard. The matter of reversion of a judicial officer.
Any date after vacation, any date. In the meantime, we'll file counter. We have already written to all opposite parties. We have not received.
What is your ground?
My ground blood, can I just,
Yes, yes, yes.
but in fact,
Ground means legal.
legal ground, yes. But just the beginning, I'm just saying, a so motor writ application was registered by a division bench of this Honorable Court, where the reservation of SCBC was the subject matter of dispute. And there, in fact, myself and Mr. Mahanti both were appointed as a amicus curiae. But while issuing notice, there was a difference between the two judges, the presiding honorable judge and the second judge. So, but order was pronounced issue notice, that's all, the court. But subsequently, it is now, the allegation is, he was the Registrar General here, the petitioner. Instead of consulting the Chief Justice, at the instance of the senior most judge, the honorable judge, he has uploaded the order. That is the entire allegation. Then that very so motor proceeding was again.
No, uploaded means the order was signed.
No, the order was signed by the only one of the judges, not the other judge. That is the mistake which has been committed by the petitioner, which according to the petitioner is a totally bona fide, because he has no occasion to see that because it was pronounced the open court, it had file was placed before him, and the deputy registrar placed the file and the concern. So he has uploaded. That is the mistake, that the entire mistake. And that is the ground that integrity is down.
And even there was a discipline proceeding where the charge of integrity being doubtful was disbelieved by the disciplinary.
And the one thing I just need to understand.
The role of the Registrar General in uploading of the orders.
Honorable Chief Justice. And by the order of the Honorable Chief Justice on 4/2021, calling upon the petitioners to show cause. And that copy of the order the petitioner wanted during the course of inquiry to be placed, that has not been, though that is the one of the, in the memorandum of charge, that is the main evidence.
Which order?
Order of the Honorable Chief Justice. And the whole proceeding has been dealt with by the Honorable Chief Justice.
Role of the registrar in uploading the.
Nothing, my case, it is total nothing. You also hear this, at least during the tenure of my lord, at least we can't do it. At least the first week, you also insist, you also at least to.
No, it will not take much time. I don't think it will take much time.
I will prepare a note of 2 pages, nothing else.
And this also, your Lordship will pass order that they may file counter also during WPC number 28873. That was tagged last time.
That was tagged, but somehow it has been.
Somehow or other, that has been.
Both the matter notice was of framing.
This matter on 6th.
Yes. 6th. I request my Lord friend at least to talk to the registrar and to file a counter so that.
Let the counter affidavit be filed. Counter affidavit, you have received instructions.
Arrivals covered by the receiver detail, we maintain say that it is filed before that.
From this campus.
Like the registered judicial has to file the cover.
Counter affidavit be filed. The is on along with WPC.
Along with WPC?
28873 of 23. 28873 of 23.
Counter affidavit be filed in both the cases. On behalf of the opposite parties, concerned opposite parties, by third. By third, you file.
File in the interest.
Yes.
Yes. In one of these cases, there was some explanation, but I'm also pending in one of the other cases, I was just seeing. This one, just before, some explanation saying.
That was item.
Explanation
It may
put forth by the registry. Yes.
Item 24.
24, that infrastructure matter, road matter. Last time I made a grievance, I have also given a
We
petition.
have already sanctioned 10.62. Earlier was 7.5 acres, my lord.
10.62.
10.62. And he has filed application for consideration of the rest area. The quarry name is Rahatpur BSQ 25 acres. The full extent of the quarry is 25 acres. From that, we have given 10.62 and in comparison with the earlier, which was 7.5 million. Let him start the quarry operation, taking the clearance.
And what about the period?
5 years.
What about the period? He had also a grievance that you have given him the query for 5 years. So he does not require that for 5 years.
As soon as he completes, my lord.
It's a problem about excavation per year. If there is a limit, then he'll face difficulty.
Yes, that is there in the mining pledge. Now, manner the grievance is.
That is the problem.
We will file an affidavit explaining the position, my lord, on Monday, my lord.
No, we will do that, but
on the reopening day, my lord. On reopening day.
see, if you don't want that the roads should be constructed, then you may take a stand.
We want, we will fully cooperate. We have already expeditiously we have done this.
That we can see.
Yes.
That we can see. Mr. Yes, all right. So we'll consider that aspect. Yes, Mr. Bhanti.
No,
So what they are saying.
But that we are not joining issue about the extent.
About the extent, all right. Only on the question of period.
If they give me 5 years, my project is for 1
We understand.
months.
We understand that.
Then the approach road. Approach road should not be in the forest area, otherwise they will not allow us transportation. Again, that same problem will come. These two things, if it is done, will not. If they allow us within 2 years and enhance the quantity, then our problem is over.
No, quantity area has been.
Each year, as Madam told
Yes.
a lot, that each year there is a cap. That
Yes.
you extract this much maximum extracting capacity. That they have spread over our requirement to 5 years. Now, unless that cap is.
The road will take 5 years.
We'll reconsider. We'll also
do it.
Yes, ma'am. We'll reconsider.
You understood
Yes,
the problem.
I understood.
We'll
And
bring
I
it
have
for 5 years then.
today I will prepare the affidavit
They have
and
to
tomorrow I'll
enhance the
file.
cap and give us an approach road. That's all.
I have
So
called
then we are just adjourning the matter for second.
second, madam.
All
Yes,
right.
by that time we'll
See,
resolve this.
Just consider the sincerity with which we are taking up this. We have taken up this matter.
Today I
Every
have
day
called
we
the
are-
officer is sitting. I will work out. I'll work out.
we will take up the matter on second.
Second.
And in the meanwhile, see the submission which is being made
Yes,
is
yes.
very genuine.
Genuine. I also agree.
What is the objection to the approach road? If you have permits, if you have permits for transporting, what
Right.
is the
If
problem?
it is a forest road, they will not allow. They say that
That
forest
was the
clearance
problem
you have
last
to
time.
get.
I will ensure that that issue is no more.
Because in the
And
plan
let us
they have
see.
given us
Let us see.
a
In fact, the best
quantity
course
which-
would have been that all of you ought to have sat together.
Yes.
All the departments and then.
Forest persons has already given and it is there in.
All right, let us see what happens, Mr. Mohanty, on second.
Today I have called the officer. If my learning senior accommodates, I can also sit with him with my officer.
Practical difficulties.
He will. Mr. Mohanty.
Oh, no, not Mr. Mohanty, Mr. Pradhan will suffice. Mr. Pradhan.
All right.
I'm sorry.
List as jointly requested on behalf of the parties, list this matter on. Second. We've taken up within second within first 5 cases.
Published.
Item number 25.
25, your lordship, kindly permit me to move this application. Mr. Swine is out of station. But here, last occasion, several times that taken time to file a counter. The position is, but the appeal will be filed before me because the 2016 notification has come. And that 22 notification is overlaps 2016 notification. There, the appeal is to be filed. They were just to inform this honorable court that appeal will be before whom. Because I am unable to file an appeal. Wherever I am going, they are saying this is not, because now Steel and Mines Department has taken over all the matters. So if they allow us to file an appeal, I can file an appeal. That will only suffice my lord.
No, they will not allow you to file an appeal. The law will allow.
Yes,
you to
I'm
file
sorry,
an
madam.
appeal.
Because my entire
That will depend on.
I've done through e-filing, but they did not accept my appeal. I done through e-filing.
All right. So who has passed the order? Original order has been passed by whom?
Tahsildar's computation regarding.
Just a minute. Tahsildar passed the order on.
But the Tahsildar assessed and passed the order at page 81 on 7/4/2021.
7/4/2021 in.
But in.
Are you sure this is not there in your date chart? Are you sure?
But here, what has happened, my lordship, kindly see my date chart. My lord, on 16/12/2020, I was allowed to
So we are on a different point altogether. The order was passed on 7/4/2021.
Yes. My lord, in fact, it is 27/7/23, which is the order demanding money from me by the Tahsildar.
So you want to challenge which order against?
My lord, I want to challenge that the imposition of demand of 1,83,09,573 as per letter.
You want to prefer appeal?
Yes.
Against what?
Against the order passing by issuing the demand raised by the Tahsildar.
What is the date?
The demand is, my lord. Date is, my lord, it is 27/7/23. Letter was issued on 16/8/23.
All right. So you want to challenge this notice 27/7/2023 before the appellate authority.
Appellate authority.
All right.
Boss,
Well,
we're challenging 2 letters. One is of the Tahsildar.
and communication by the mining officer.
No. Second, that amount is lesser. The second one is more.
More.
For that, the mining officer is demanding.
Mining officer has given 2 letters in which I have been asked to take 2 demands of a period in which they say that you have extracted without taking a clearance.
So is it the same period or 2 different periods?
Same period is.
So the amounts are different.
Amounts are different because I had deposited certain amount. After that, they deducted and found that this.
All right. Let us see the order. Let us see the provision. Appellate provision.
Yes. Now that is 2016, 2022 Gazette notification. My lord, it is there with me an extra copy.
27 December.
27 December
2022.
27 December 22. And before that?
Well, before that, the appeal was to be filed
concession
before the sub-collector. Well, paragraph 14, I have given the details. My lord, may kindly see paragraph 12. I've given that detail.
Who is the competent authority?
My lord, now the competent authority, though I have filed an appeal before the sub-collector refused to entertain the appeal.
Mr.
I filed before the deputy director.
When we are saying who is the competent
My lord,
authority,
now it is the deputy director.
competent authority as mentioned in Rule 46.
Yes, sir.
Please come to Rule 46. Do you have the book with you?
My lord, that notification, one copy I have just had.
Notification is not required. Notification is just substitution.
Yes.
Incorporation.
So if there is the come to the notification.
Yes, sir.
Come to Rule 6. Please read Rule 6.
Yeah.
Please have it.
I've given mine.
My lord, prima facie as it appears, because the Gazette notification is 22nd and 27, 12, 2022.
Let us understand.
After that,
Let us
there is no
understand.
jurisdiction.
Let us
Because it's a
My lord,
order.
any person aggrieved by an order of the competent authority within one.
Who is competent authority?
My lord, competent authority is the Tahsildar who will first deal with
How
me.
do you say that competent
Because
authority is
that
first?
time,
After this amendment,
the appeal lies to the deputy director.
Mr. Bose, are you deliberately doing it? I think you will understand.
No,
After this amendment, could the Tahsildar have passed that order?
no, the Tahsildar passed the order under, my lord, annexure. Yeah, that is the order under annexure.
Mister, we are putting a very simple question. There is an expression competent authority in Rule 6
Yes, ma'am.
of 2000, amended Rules 2016,
Yes.
22.
Yes.
What is the meaning of competent authority? Where has that been defined?
Well, a competent authority has been defined.
After the notification. Not gone through, we can keep it after recess also.
Well, let me call it after this. I'll assist.
It will take time, Mister. Unnecessary. Since you are not in a position to tell us as to who is the competent authority, we are repeatedly putting this question. And you are saying that the appellate authority is competent authority. Appellate authority cannot be competent authority.
Original
competent. The moment we say competent authority, you will have to refer to the rules.
Yes, ma'am.
How the competent authority has been defined. As requested on behalf of the petitioner, list this matter on 3rd week of January. Yes.
Item 26.
3rd week of January.
Lordship, we need around 2 to 3 weeks time to file a counter affidavit to lordship.
They have taken time.
How many? How many at January?
2 at this.
2. That we shall grant with some cost. Let us do this.
Dash is,
Huh?
he has some personal inconvenience, Ms. Dash was the one who was filing. Time after vacation, my lordship.
Very difficult, madam. The first order was passed on 3/10/2024. His portal is blocked. And we wanted to know whether any so-called notice was issued or not. Then again, the matter was taken up on 4/11. You are
Staff
speaking.
guidance, Your Lordship, she is.
And we wanted to know whether the opposite parties intend to block the, unblock the petitioner from Portugal.
Whether they wanted to unblock after the minimum giving
All right. 5,000, despite the sports orders. The counter affidavit has a repeated order. The counter affidavit has not been filed. What do you want? Or list this matter online. First off, if in the meanwhile counter affidavit is not filed, the state shall be required to deposit a sum of rupees 20,000 in the account of welfare system.
She normally doesn't file.
27.
But today I filed my regional recruitment action asking it.
Copy may be given.
Yes, yes. This is
On behalf of the states that he intends to file. He has filed a rejoinder affidavit. You have filed. That rejoinder affidavit has been filed today. Let a copy of this rejoinder affidavit be served on learned AGA representing the state. Does this matter on when?
First week of January.
Second week of January. Yes.
Overage persons had got that pension. That is the allegation.
Item 28.
Lordship, I'm attending discussion 14 and 14 both the matters, Lordship. On behalf of Mr. Das and Lordship, can you remember last offense regarding rejection of technical bid? And I have taken special notice on special messenger.
Today I am appearing on behalf of opposite party number 2 and 3 mine.
So what do you want?
I will file my response file.
But Lordship, only I pray, Lordship, because here the opening of technical bid, Lordship, rejection of technical bid. In the meantime, they will go for Lordship, opening of financial, it will be interrupted. Lordship, any decision, Lordship.
Any decision will be subject to final.
Lordship, that.
Mr. So-and-so has entered appearance on behalf of opposite parties number 2 and 3 by way of a colored family. So stop. He seeks adjournment to file counter affidavit. So stop. List this matter on when? 4 weeks.
First week of January, because like tender matter. That's it.
4 weeks, so they were 2 weeks, they are closed.
Lordship, so first week.
Second week of January.
Lordship, second week.
So, till the next date. It is observed that, that any decision in the matter of finalization of interest shall be subject to final adjudication in the present.
Yes. Both the matters.
28 and 29.
Both.
29 I am referring to the OP2 for corporation.
So you are appearing in one, and he is appearing in one.
Yes.
In 29 I am referring.
Same order both.
My lord, item number 22, interim order may be continue. Urgent to 6-1. Item number 22, my lord. Urgent to 6/1/2025. In that case, interim order is in force. Interim order may be.
What is the interim order?
Stay operation of the Honorable Single Judge.
You just
You are for the bank or what?
My lord, my item of
Tag with you in the meanwhile. To the next date.
For delivery of orders, WPC number 2373 of 2024.
We are closing the proceeding with following observations and directions. All the police stations and the police outposts in the state of Odisha must be fully equipped with aptly placed and duly located CCTV cameras by 31/3/2025. Their integration with the central monitoring system through video management system must also be completed by the said date. The state officials, police personnel shall be under obligation to strictly follow the SOP formulated by the state government on arrest of and interaction with the members of armed forces in police stations, as has been noted here and above. The said SOP should be duly publicized and effective steps should be taken to ensure that the police personnel are made aware of the provisions of the SOP. The said SOP should be circulated in Odia language to all the police stations and the police outposts of the state. The state government and the police headquarters must ensure that the assurance given to this court in the affidavits filed by Mr. Gangwar is not breached. We reiterate that no observation made in the present order should prejudice the police investigation being conducted by the crime branch or the inquiry being held under the provisions of the Commission of Inquiry Act. Before we part with the present order, we place on record our appreciation for the assistance extended by Mr. Gautam Mishra and senior counsel appearing as amicus curiae at the court's request, befitting his status as the first law officer of the state. And Advocate General Mr. Acharya has assisted this court with all fairness. Mr. Gangwar discharged his function as an officer of this court and has acted proactively in obtaining inputs and carrying out the work of installation of CCTV cameras in the police station and police outposts, as well as the integration in CMS. We do record our appreciation for his assistance extended to this court. The writ petition is disposed of accordingly. You can see the directions and the order will be uploaded today. And you can go through.
Sometimes small typographical errors create a lot of confusion.
My loss.
One.
I don't understand one case. I have got a lady. It is very urgent that this matter is taken up tomorrow.
What is that?
Not tomorrow, later.
Right, good.
I hope you've written down in your memo what the urgency is.
So urgency is a old.
All right, we are.
Old lady of us has 70 years.
Weekly list item number 10. Item number 10.
Then I submit a memo, Your Lordship. Out of 46, 12 numbers of contempt application has been, already we have received the compensation. And a list also attached.
Where is your list?
Madam.
Your list?
Madam.
Yes. Okay.
Agree. Received.
It is stated by learned counsel appearing on behalf of the petitioner that this court's order violation of which has been obtained in the present contempt application has been complied with. Top, the contempt proceeding stands dropped accordingly. 1 to 12.
One contempt number 5540, which has been rejected. You not see liberty to file challenge this.
5540. The in compliance of this, while complying, the petitioner's claim for grant of compensation under the against land acquisition has been rejected, comma, in compliance of an order passed by this court. So stop. In such view of the matter, since the order has been complied with, comma, the contempt proceeding is dropped. So stop. Learned counsel for the petitioner shall be at liberty to question the correctness of the order of rejection before appropriate forum in accordance with law. These are 13. Then one matter already withdrawn. One withdrawn. What about the rest?
Rest will Lordship may keep this matter to 13 of January. In the meantime, we'll comply. All the
rest of the cases.
13.
I may pardon to make a mention of Lordship's permission. One matter, order reserved rehabilitation matter of poor lady.
All right. Give the number.
Yes, sir.
After holidays, you may find the judgments. And very happy New Year to all of you. Will not be here tomorrow.
You find anything? Yes.